WhatsApp is 07440420432. We had some very good questions last week, actually, a couple of weeks ago, actually, which are interesting ones which could actually help the community at large.
Absolutely.
So, Gavin, how have you been?
I'm all right, Ajaz. I'm not too bad. Tried to have a reasonably relaxing weekend. How about yourself?
Same here. I mean, I've just actually ran here from my son's cricket match. He's playing cricket this morning, so I've seen him bat. Couldn't see him bowl because there wasn't enough time. Hopefully, they win. Let's see how it goes. Right. Okay. Now, Gavin, any interesting matters going on, or anything updates in the law that you can share?
Well, it looks like redundancies are on the rise again. We've got Pizza Express, which are closing a little over 70 of their outlets across the country.
Yeah.
I think a couple of those are reasonably local outlets in the West Midlands as well. So that's unfortunately going to see a number of people lose their jobs, potentially go through redundancy consultation processes, and they may choose to try to settle these people via way of settlement agreements, at which point they'll probably need some legal assistance there. ACAS is a good starting point if anyone's going through a redundancy consultation process, although if they feel that there are significant issues with an unfair redundancy process, then they should always seek some legal advice out there just to make sure that everything is being done properly. There's also STA Travel, which has closed their doors and ceased trading yesterday. That's a nationwide travel agency which predominantly targeted holidays to students, but because of the coronavirus situation, and I suspect a lot of students not going on holiday at all, they have ceased trading now, and a lot of people will also be equally affected there as well, and a lot of people going through redundancy processes, probably with whomever is dealing with the wind down of the business.
Right. Okay. That's interesting times. This year is, for a lot of people, a write-off.
It is. It's 2020 certainly a year that I think most people would be quite happy to
spend in bed.
Call it a day.
Yeah.
Call it a day altogether. It's not been a great year for many businesses really, or many individuals themselves. I suspect some of the clothing brands which have been able to readjust themselves to providing medical supplies, face masks and such, surgical gowns and masks, they'll be doing well out of this. But there are some that have. UK-based ones have done well out of it. Some Spanish ones have also turned themselves around, which did very well. But it's hard to say how it's going to look. The high street's taking a significant hit. And you've only got to walk the streets of Wolverhampton to see that there's less people, less footfall than there was. People aren't coming out as much. People aren't spending as much as they were. And that's going to have a knock-on effect throughout the economy. Albeit, that said, the stamp duty change seems to have been enough to inspire significant confidence in the conveyancing market at the moment.
Definitely. I don't know how much of an effect it is having per se, but we are definitely getting a lot more instructions, a lot more inquiries. Estate agents are busy. I've seen obviously there's quite a few estate agents right on the street where our office is, and they're taking on more staff.
Yeah,
they've taken on more staff they can't deal with the demand.
Yeah,
how long that's going to last? Who knows? Maybe 6 months, maybe a year, maybe longer. But I personally think Christmas, a few more redundancies, after the furlough finishes, and that might burst the bubble a bit.
That's a big question in itself, though, isn't it, Ajaz? Is furlough going to end at the end of October, or is it going to end up being another U-turn by the government whereby furlough is continued for specific sectors to assist people and businesses to retain their workforce for that bit longer, to try and take them through into sometime next spring, maybe? I know in Germany they've extended the furlough period to 24 months now. So that's an interesting development in itself. I'm not sure if they're the first country to have done that, but I certainly did note that yesterday, that the German government has opted to do that, and that makes some sense. I can see why they're wanting to do it, because it is helping businesses and individuals be able to stay afloat during what is a period where some businesses just wouldn't be able to trade at all.
Very true. Very true. Yeah, who knows? Well, but as we do have the right information for you, we will be here and we will update you on anything in relating to furlough and any other legal updates that we feel you guys should know about, or maybe explain to you whatever the government is saying. Sometimes the statements released on TV don't go into depth as much as they could do, and therefore leave things very vague. And that's where people like you and I come in, isn't it, Gavin? We can then explain that, decipher the message.
Yeah, and I think the government message generally throughout the pandemic has been one of confusion quite frequently, whether it's been on legal points or whether it's been on just general points of what people ought to do at the moment. I think they've suggested that in Blackburn people are no longer allowed to socialise. However, cafes, pubs and restaurants are allowed to remain open. So the contradiction in terms there is very
you're
odd.
saying Blackburn. I heard about Oldham yesterday as well. But at the same time, don't you think this eat out to help out is actually adding to it? I mean, I know where the Chancellor's coming from with the incentive. It's definitely good for business for these businesses that have been probably closed for 3-4 months. Definitely good for their business. However, at the same time, aren't you actually, also causing a problem with social distancing issues?
Yeah, I think so. I mean, I attended a pub not too far from us a few days ago on was it Wednesday or Thursday? So it was outside of the Eat Out to Help Out scheme timing for it. It was very spaced out and such. They did say they were taking part in track and trace and wanted people to sign up their details on an app for it, but there was no enforcement to that at all. They did try and do a fairly good job. So if you wanted to have a drink outside, you didn't come inside, you did your order at the door, and you had hand sanitizer there as well. And the outside tables were spread out. If you were eating inside in a particular area, again with the tables well spread out. But it's not necessarily a situation where you're thinking that it will help stop the spread of the infection, because you are still bringing together groups of people that will pass one another that may well have the virus. And it's the same with reopening of non-essential retail to some extent. People are going to be passing each other a lot in the shops.
Yeah.
But then how far do you go? Because then supermarkets, they were always allowed to open, and rightly so, otherwise no one would be able to get any food. And you were always passing people in the aisles there too.
That's true.
It's and probably within 2 meters of one another, because despite all of the best intentions, albeit some of those seem to have been reversed by Asda now, I've noticed that they've taken their one-way system out.
Have they?
Yeah, they've taken that out, and they're not funneling people as they once were. I thought that was
Probably
a bit
because
odd.
some people don't listen anyway.
Some don't, but the majority were doing a reasonably good job with it, and people were keeping the masks on. The odd thing is staff members not wearing masks, although we do have to. So it's just that just seemed very odd to me.
Yeah, I'm finding that difficult actually. Trying to remember to take the mask with you when you leave your car or leave. I think Friday I said to you, I left the office. Went to the post office to post some letters, got outside the post office and thought, I've not got my mask. Walked back, and then then I thought, well, I'll go later.
Yeah, well, at least you weren't in the queue for the bakery, and the queue for the bakery felt like a mile long.
the queues at these restaurants on these eat out and help out days are so long. It's unbelievable. I was in Ladypool Road. I'm not sure whether you know of Sparkhill, Sparkbrook, but it's a lot of Asians around there, a lot of Asian restaurants. So I was there a few weeks back on a Wednesday night. I actually at that time it didn't click to me that it was eat out, help out. Why are these queues? And the guy with me said, oh, because of this. We ended up going to a restaurant that didn't actually have the offer because there was no queue. So I couldn't be bothered waiting in queues anyway.
I don't know if that scheme's really going to be very helpful because I'm not sure if it's necessarily inspiring people that wouldn't have ordinarily have gone out to eat out anyway.
Yeah.
They're just perhaps funneling them into a certain section of the week where it might have otherwise been a bit quieter.
Yeah, I suppose. It might reduce the impact on the weekend as well, I suppose. But saying that, I went past a Weatherspoons yesterday, and I went past it on a Tuesday or a Wednesday as well. Queues on both days. So, yeah.
Yeah.
And they weren't socially distanced queues either.
No, I've been hearing that Weatherspoons hasn't really been abiding by the social distancing rules very well at all. I've not been for waiting anywhere like that, so I'm quite happy.
Right, we've got a question here now, Gavin.
Oh, good.
Now, before I go on to the question, again, I would like to remind the listeners that if anyone has any legal inquiries, legal questions, please give us a call in the studio 01902 972 150 or WhatsApp your message to us by text on 07 440 420 432. And if you are watching us on Facebook Live at the moment, the numbers are running across the bottom of the screen. So the question, Gavin, is, hi, I'm looking for someone who might be able to give me some legal advice. Okay, we may be able to, regarding an issue I have with my photographer. It's going to be one of those wedding ones. There's quite a few like that nowadays. So I got married in October 2019 and paid in full for pictures and video. I was told we would receive the video and pictures within 8 to 16 weeks. Video was due to be delivered on the 29th of March 2020. We received the pictures in June. However, we still haven't received the video. I have contacted the photographer many times and he just keeps on pushing the date further away. I was told in June we would have the video within 4 weeks, which has now passed. I have paid in full and feel like we won't get what we paid for. I do not have any wedding insurance. Any advice on this would be appreciated. Gavin.
Yeah, so I suppose the first thing that struck me is 2 to 4 months to receive wedding photos and the video.
That is a considerable amount of time.
It is, isn't it?
But I'm assuming it's an Asian wedding, a fair few events, editing, and also I believe these photographers are very busy, so they just continuously churning them out and then give a good length of lead time for receiving them. I remember when I got married 13 years ago next week actually. That was about 3 months 4 months at least before we had our pictures.
Wow, so that's actually quite a standard timescale then. Amazing. Well, I would say that it is a concern that this individual hasn't had their video at this time, and it is questionable now that we're into August. The pictures arrived in June. I can only assume that the original delivery date was lost on the count of a lockdown, because June would be probably where things were easing up a little bit more and people were able to get out and about a bit more. I'm not sure there. It's hard to say from the detail. But if the video hasn't turned out now, then that is of grave concern. And you do have to wonder whether or not you're ever going to get them at all. So at this point, you're probably going to want to look at a couple of different routes for it. Depending on the method of payment that you'd gone through, you might try to look at if a Section 75 chargeback if it was by way of a credit card. You can turn around to your card provider and you can let them know what the situation is, let them know that you hadn't received this element of the services that was to be provided to you, and therefore you say this much money should be returned to your card as a result of it, and that you've been trying constantly to get this video from him, but you're not getting anywhere. And now, having been approaching a year since the event, you're concerned that's never going to happen. The alternative would be that you could write a letter before action to him, providing him with the opportunity within 21 days after that to either provide the video that he's supposed to provide or provide payment for the video element of his services, which he has not provided. And then if he doesn't choose to do either of those options and disputes it for whatever reason, then you've got that option then to start moving towards the small claims proceedings if you wish to.
The only downside there, they can't redo their wedding.
Yeah, so if they lose that video, it's gone forever, isn't it?
Yeah.
It's not just a monetary amount.
Exactly.
It's memories, isn't it? So it would be better for them to be able to recover it. And there's no harm in writing to him one final time and just saying, look, if you don't provide us with this by a certain date, then I'm going to have to get in touch with either my credit card company, if that's the way I paid, or I'm going to have to start looking to take the legal route with it. And I don't want to have to do that. But, I really do want my video. And it has now been nearly a year. And I don't think that's an unreasonable point to make. But, you got to just hope that they haven't lost it.
Yeah, that is an issue which, well, I suppose they could ask the question, why are you not providing it? Is there an issue? If there's an issue, let us know so that at least we can,
do something about it. Yeah, I think that's a fair answer.
Yeah. So that's our answer for you. There is a legal route, obviously, but the legal route you would be claiming back the loss monetary loss. I don't think really the court will.
Loss of enjoyment is a tricky one. It mostly applies in holidays. You can apply it. Interestingly, to weddings, it does apply to weddings. If you've taken a holiday
abroad,
to have a wedding, you can get increased levels of loss of enjoyment as a result of that. But whether or not you would get it for not having the video, because it will, I don't know, not help you reinforce your memories so well of the special day, possibly arguable, might be worth a look and a consideration, but I wouldn't put it down as anything more than a punt, in all seriousness.
Yeah.
It's not been previously tested, so it's one of those grey areas where you couldn't give somebody a straight answer on it.
Well, you could try it.
Yeah.
you could be the test case.
It could be a test case.
Yeah. Right, okay. Guys, I hope you've enjoyed our show so far. If you have any questions, 07440 420 432 on WhatsApp, please. You're welcome to ask any legal questions you may have, or you can call us in the studio with your question on 01902 972 150. Gavin, we do have another question here. In fact, they're coming in. We've got about 3 or 4 questions here.
Okay. Let's
see what the next one is. Let's see if we can. We've got 5 minutes before we go into the break. Let's see if we can answer this one before going to the break. Interesting one. If a legal firm, they're not naming the firm, if a legal firm is sending letters, can they keep saying you need to reply with 7 days, within 7 days, or so X date, which gives hardly any time to look into the matter or seek independent advice, and it's in relation to a neighbour dispute. So I think we covered neighbour disputes a weeks back, weeks back, didn't we?
Yeah,
a couple of neighbour disputes. So 7 days, that normally 7 to 14 days.
It's the common one, isn't it? Come back to us in a week, usually. If you're self-representing, then if you turn around and said to them, look, a week's not good enough, we are trying to seek independent legal advice on it at the moment, we will probably aim to come back to you within the next 2 to 3 weeks, or our appointed solicitors will come back to you in the next 2 to 3 weeks, then I don't think that's entirely unreasonable. Presuming that the circumstances of that are not that there's a court order that needs to be obeyed with particular dates on it, because that's not necessarily voluntary in itself. That's something that you need to follow, really, court dates. And usually law firms which are able to vary those court dates slightly depending on what it is for and whether that can be done by consent. And there's a limit to the number of days that you can extend dates for and the purposes of them, really. So yeah, they can do that. It is quite common to see sort of a 7 days for a reply kind of response. A lot of that comes down to trying to manage their clients' expectations and when to expect a response, and being able to productively structure and control whatever's going on. So if you're proposing an alternative date, that doesn't necessarily mean that they'll come back and say, well, you didn't respond in 7 days, so that's no good. It might well be that they'll just have to report back to their client and say, well, we see the other side seeking independent legal advice and they're expecting to come back to us within the next 2 to 3 weeks. That's quite sensible approach to it, and I don't necessarily see that causing any issue.
Yeah, and I agree. So maybe with the COVID and that, they should be allowing more time. What do you think?
Well, I mean, you've probably seen this yourself, but some law firms haven't exactly been the quickest at responding to standard correspondence, even sent via email, during this period. And it's a little unusual because electronic communication's been around for a very long time.
That's right.
These lawyers predominantly, if they are working remotely, it's only working from home.
Yeah.
So I don't understand why they're not necessarily always quick to respond. And there have been occasions where I've had to send out letters which I'd initially sent by email on the thought of it being cheaper, more effective, quicker,
yeah.
to having to revert back to the post in the hope that somebody in the office will pick up on the fact that someone's not responded to this letter and it should have been responded to when it was originally emailed, which just seems to be the counterproductive way of having to do it.
Maybe we should CC in with their general info one or inquiries one as well.
Well, that's it, because you don't know if someone's been furloughed, do you?
Yeah.
Or if someone's perhaps even been made redundant and they just haven't updated.
But they should
things.
have an out of office on if that's the case.
They should.
Yeah, but no, we all had the same issue, haven't we, with getting responses from other side. They say, "Oh, we're working from home." Yes, you're working from home, but surely you have a computer at home. You know, you're not working on an abacus.
One of my current cases is the client said, well, we tried to deal with the solicitors ourselves, and she just said to us that she didn't know what information she was going to be able to provide to us at this time. And this was in a matter where they'd been very specific about a list of particular documents which they were going to rely upon, wanting an extraordinarily large amount of money as a result of it. Yet they didn't seem to have the necessary documents to hand. And I've now received a letter effectively saying, well, I'm working remotely, so I don't have them. I don't really see that as a good reason. They should be scanned onto the system. I would expect them to be there.
With case management systems nowadays, you know, I'm fairly sure all case management systems are quite up to date, where everything gets scanned to there. So I can't see any reason why they don't have access to that.
Yeah, poor systems at the firm, potentially.
Unless they don't scan. Unless their firm doesn't scan, they're still, think they're in the 70s and 80s.
Oh gosh!
Yeah.
Imagine
and that can happen. When I took over my firm, everything. I mean, there's only one computer. The solicitor didn't have a computer, just a dictaphone, and some of the stuff was done on typewriters. And you should see now our ledger cards. They were. Right, guys, we're back. You're welcome again to the Legal Clinic with me, Ajaz Ali, and here on Radio Ramadan, Wolverhampton. I have with me again my friend, colleague, Gavin Ward.
Hello
Sorry,
again.
Sorry, I'm terrible with names. I keep forgetting even my own children's names, as you are aware.
That must get very difficult when you go into school to pick them up at the end of the day.
Yeah,
they ask you which child are you after. I've
luckily, they recognise me, and I have to pick them up from the different entrances. So
you just hold up a card going, Ajaz.
Right, guys. If you have any questions, any legal questions, please message us on 07440 420 432, or you can obviously call the studio on 01902 972 150. We'll look forward to either speaking to you or answering your questions. We do have a few questions here already, but before going into the questions, there's a couple of other updates that I'd like to cover. Now, as many people would be aware, for especially this is especially for landlords really, or tenants, there was a back in March, it was announced that evictions could not take place till, I believe back then it was till June, and then it was extended to start of September. And Gavin, is there an update there?
Yeah, the government has opted out of pressure from the opposition and other groups to extend this. Now, the extension's not very long. It's 20 days. They've only extended it to the 20th of September. It's not a vast amount of time, and it's not entirely clear what good that will necessarily do for those affected by it. It does indicate that the government has got some reluctance to wanting to extend it any further. I suppose the knock-on effect is that if a landlord is not receiving rent or is not receiving his whole rent for it, if he has lending against that property, then he could also find himself or herself in difficulties there too. And that could then mean that the lenders are turning around to him in a similar ways to how the landlord might turn around to his tenants that aren't paying. And it sort of filters up the chain necessarily. That is a possibility.
I think at this moment in time, there's a lot of landlords who are probably waiting for as and when they can evict. One of the reasons for it, when it was announced that mortgage holidays would be, was it 2 months or was it 3 months?
3-month mortgage holiday.
So there was a 3-month mortgage holiday. Now, a lot of tenants took that as, okay, my landlord's got a mortgage holiday, surely I've got a rent holiday, right? So they were of the opinion that they don't have to pay rent. I had a fair few inquiries on this matter.
Oh.
Yeah. So they were of the opinion that they don't have to pay rent because the landlord doesn't have to pay their mortgage.
Well, the problem is the covenants for paying rent aren't held back. Or they're not, shall we say, withdrawn for a period of 3 months. The rent that you would accrue over that period, or the mortgage repayments that you would need to repay over that period, they'd still exist.
Yeah, with interest.
Yeah, so it's not a good idea to be looking at it as I can take this break. If it's a case that you look at your finances and you're thinking over a 3-month period, right, by the end of those 3 months, I can definitely have afforded to have paid him the rent and be able to pay the rent going forward, in the similar position for the mortgage.
Yeah.
But I'm going to have to do it in a different, slightly different way as to when I pay it during that period. Then fine. But if you're looking at it in a sense of, well, I've got a holiday from it and I don't have to pay it, then it's going to come bite you. Whether you're the landlord with a mortgage or whether you're the tenant with a rent to pay, that's going to come and bite you one way or another.
Absolutely. But as I said, many of these tenants would have thought, well, they didn't understand the concept, I believe. They didn't understand that the landlord, the holiday doesn't mean it doesn't need paying at all. It just means it's deferred.
Yeah, and I think that would have been the way to put it, really, wouldn't it? It would be better to call it a mortgage deferral period or something like that, or a rent deferral period, because then it doesn't sound so attractive as calling it a mortgage holiday or a rent holiday.
Yeah.
Because then people think, oh, well, I've got a gap. I don't need to make this gap up. And that's what's going to cause them problems. I mean, there's an element of perception and probably poor government announcement.
And on that note, there were quite a few people who have taken advantage of this mortgage holiday, and then when they went to renew their mortgage, they've been told, no, we don't want to, we won't renew your mortgage because obviously you can't handle your finances.
Oh, it's impacted on people's credit ratings as well. Oh dear. Well,
It is. Whether it's
that's unfortunate.
whether it's credit ratings per se, or whether it's just with those, that same lender. You go for a new product, and they think, well, no, actually, well, if you couldn't pay, we're not willing to
Well, this is it. I mean, if
renew it.
yeah, because it's a risk basis for the lender as well, isn't it? They want to know whether you're a good covenant for your payments. If you've always made your repayments to them, they're more likely to lend you money. Or if you've got bank accounts with them and you've managed to stay out of your overdraft through a large extent, then by and large you're going to be in a better position to be able to lend money off them because they're going to see you as a good covenant for the future.
Absolutely.
Whereas if you've had to take I think it's a bit harsh though, if you've had to take this particular payment holiday, that they would take that into consideration because they are kind of erroneous events which have happened unexpectedly, rather than sort of the normal run-of-the-mill economic changes that can happen that can cause people to not be able to afford it. So I think it is a bit harsh, but I can sort of see where they're coming from.
But yeah, as I was saying, there's a lot of landlords there waiting in the wings to get those tenants out. In fact, I was approached by one yesterday.
Oh dear.
Yeah, so seeing him on Monday, see how that goes. Right, we have another question here, Gavin. So the question is, in October 2019, our company got taken over by another employer. So the company got taken over by another company. Up until now, they have kept the original employee contract agreements, employment law, and issued us with a letter saying they employ us, but original contracts stand under the 2-pay rules. But they have told us they are issuing new contracts with changes. They are taking each person in separately to verbally explain the new contract, but not at that point given the new contract. People are asked to sign an agreement that we understand the changes verbally explained to us. And then we get the new contract and see no weekend overtime pay, just normal rate. Wording changed and lots of new procedures added. Can they do this, even if 2-pay protected? Thank you in advance. Interesting one there, isn't it, Gavin?
Yeah, I mean, the short answer is yes, they can do it, but there's a way in which they can do it. So they are honouring the original contract of employment for a time. They've now decided, after a period of ownership of acquiring this company, that they want to change some of the terms applicable to either certain employees or all of the employees. It's not entirely clear from this. They're holding meetings with people, which is essential to do that. They do need to meet with the affected individuals, and they do need to discuss the changes of the terms and the impact that it will have on them. And if they're asking them to sign an agreement, it sounds like they're asking them to potentially sign perhaps a side letter to the employment contract to say that these certain terms will change to reflect, I believe he's saying no overtime pay on a weekend, just normal rate.
Yeah,
seems to be the key issue.
Yeah, I guess they were previously in receipt of overtime pay, so maybe double time or time and a half.
So the important thing for the individual affected to consider is, do they want to agree to the change? It is a choice. That's why they're consulting with them. If they don't want to agree the change, then they'll need to consider whether or not they want to leave their employment, because the employer will say that the changes will take effect most likely within 30 days of the meeting or from when the agreement is presented.
But surely in that meeting they would have explained these changes.
Yeah.
That would be the whole purpose of that meeting, that, okay, yes, we want to change, but these are the changes we are looking to implement. Do you agree? So
if he's saying he doesn't agree,
then he shouldn't have signed the document.
Well, he shouldn't sign the document, and if he has signed the document, then he's agreed to the change, and that's that really, because he's employed.
Or is he saying that this is not what they've explained in the meeting?
Well, if he's suggesting that they've explained option A, but it's actually ended up being option B instead, whatever the alternative is, then that is a difference. But I suspect that they said there's a lot of changed wording and there's a lot of new processes and procedures that have been put in place.
Yeah.
Now, employers can implement new policies and procedures all the time. They don't need to necessarily run through that as a change of the employment contract. But they terms that are going to affect someone's employment, so things like their pay, they would need to consult with them and discuss that a bit more. And then it's going to be up to the employee to decide whether or not he's happy with that change. Because if he's relying on that overtime payment each week to help him stay or her stay afloat each week,
Yeah.
then they might be thinking, well, I'm better off going to work for Joe Bloggs down the street instead, rather than staying with these chaps. But in the current economic environment, you question whether or not they would want to just stomach that and maybe look elsewhere if that term displeased them. But yeah, they have a choice to make, and it's a two-way process.
Okay. Right. Hope you heard our response on that and you are satisfied with it. If you have any other questions on that, please get in touch. Again, I'll remind the guys listening to call us and speak to us. You can call the studio on 01902 972 150. But although I think people who listen to our show are quite shy, they'd rather text than call.
That's all right.
Yeah. And also, you can WhatsApp your text message to us with any legal inquiries you have on 07440 420 432. Let's move on to the next question, Gavin. Can I have advice on the following, please? My property, which has rights of way for electricity board at the rear boundary from one side to the other, approximately 1 meter wide strip. One, what rights do they have to enter my property without my permission each time? Currently, it's all fenced and gated. 2, do I need to make arrangements for them to enter? We had a previous falling out with when they regularly entered unannounced through my side gate, for which they had a key from the previous owner. For the last 2 years, I have changed the locks and they have had access from another route. Any advice appreciated? Right. So I guess this person does not want the electricity board to enter his premises.
Yeah.
I'm quite curious as to what reason they have to regularly enter his premises.
I would suggest that there might be something wrong with the equipment that they've got fenced off in their compound if they're having to come in and out quite often.
Yeah.
Because ordinarily you wouldn't expect them to be coming in and out very often. It'd just be as and when, probably checking it to make sure it's all working okay, and not really bothering the tenant, or should I say the landowner, very much. I would suggest the first thing they want to do is just check the rights of access, the easements on the title
Yeah.
for the property first of all, and see what the electrical board are entitled to do, because they must have some access rights to be able to access it the way they did. And if the previous owner has given them a key, gone so far as to give them a key, that would suggest that they probably do have the rights.
Considerable rights.
Yeah.
When you purchase this property, you should have had a report on title, which your solicitor would have drafted. In that report, all of this should have been covered. You should, how often, etc. If there is any covenants, or if there is any document which gives them this right, that should have been in that report. So check your report, I would say, first of all. I'll leave the rest of the answer to you, Gavin.
Yeah, I think you're right there. I think you do need to check the report from the conveyancer to see what the position is on that, because it might already be properly outlined for them. The conveyancer should have also provided them with the office copy entries, which would detail out any easements on the register with land registry, to understand the exact wording and the extent of that access right as well. Note that the question also inferred that they're now accessing via another route. I'm not sure whether that route is supposed to be through this particular owner's land now as that gate being, these change the locks on the gate, or whether they're saying that they've just found access from the roadway now, or some other way, or a different
And if
neighbour
there was
instead.
another route, why did they have to trouble someone?
It might have been that
Unless
that
it's
was the
through
most easy route.
unless it's through a neighbour's.
Yeah, and it might well be that they're going through the neighbours now. Perhaps it's a case of there's a house, back garden, whatever their hobby's there, and there's another neighbour there. And they're just going through the easiest approach possible.
Yeah. So yeah, I'd go back to your solicitor. Unless you have the report at home, I'd go back to your solicitor, ask those questions, say, well, what rights do they exactly have? You don't want this to be turned into a legal battle if if you are not supposed to lock your back entrance somehow, which you seem to have done. Right. Yeah, it's an interesting one, that one, but I suppose we'd be able to answer it more thoroughly if we had more information.
Well, it also, they don't want to cause themselves any kind of dispute with the electrical board, because if they are blocking them from having a rightful access across their land, they could end up finding themselves facing an injunction from the electrical board not to, or to return the locks to normal, or to provide them with an access key so that they can access it as they want to. So they don't want to be putting themselves in unnecessary risk on that.
True. Right, the next question I have, I believe this will be our last question, unless someone else does send a WhatsApp with a question. The WhatsApp number is 07440420432. Right, it seems like a very similar question to the first question, actually, Gavin.
Okay.
So someone said, I got married last year and paid my videographer in full before the event and still have not got our video. It has been a year on now, and I'm starting to think he may have lost footage. Could you offer some legal advice? Thank you in advance. Now, on this one, on the last one, we suggested that they need to check whether they've lost the footage, because I think had it been a year?
Nearly a year.
Yeah, well, this one, it has been a year. And they do suspect that they've lost the footage.
Yeah.
But I suppose as far as the legal stance is, it would be very similar to the previous one, right?
It would be very similar position to it, and I suspect, as it's something that you would like to get back for sentimental purposes, not just for the fact that you'll have paid so much out to receive a video, you'll be wanting to secure that footage, if it exists, as quickly as you can from the photographer. So I would try and contact them as much as you can, and see what the issue is on their side. Try to understand that a little bit more, because a year is a very long time to have not processed the footage.
And especially, I would say, with lockdown, your videographer probably hasn't had much work on. So, I mean, if he can't sit down and edit his videos, what else is he doing? So, yeah, the conversation needs to take place with your videographer. Okay, why is it that you're not getting back to us? Why is it that the video is not ready yet? Is there any complications? Have you lost the footage? Have you lost the footage? Is it misplaced, or God knows where? What reason it could be?
I think if things develop and it seems like they're suggesting, we're not entirely sure on where it's located at the moment, or we're not sure if we'll be able to ever get you the footage, then obviously if they paid in advance via credit card, then, as I said earlier in the show, there is the option to do a chargeback via the credit card provider, based on that evidence.
Insurance, this one hasn't mentioned insurance. So.
Wedding insurance might be an option as well, to go through the wedding insurance. But I think if you had a choice between your chargeback and the wedding insurance, I'd probably choose. Well, actually, I suppose you're not going to be renewing your wedding insurance, so you don't care, do you? So,
you never know. You might decide, well, this one hasn't worked out. The videographer's rubbish. Mine's not worked out. I'm doing it again.
Yeah, exactly. So yeah, you could go through wedding insurance for it as well, or the other option is obviously the more gritty option of taking it to court, small claims, try to get that money back for your videos. Really, sending them a letter before action, giving 21 days with which to either provide the video footage or a refund of the money's paid for it. If he doesn't do so, then pursue it through the appropriate legal route.
Well, there may be a reasonable answer.
There might be a reasonable answer. A year is a very long time. It doesn't sound promising as to
Well,
whether the
maybe for
footage
now,
still exists. So
I'm just throwing ideas here, but maybe if it's at a location where he can't go because of COVID,
yeah,
can't re-enter, maybe something like that. You need to find out. You need to ask the question.
stored in the safe of a care home or something.
Well, talking about care homes, I went to a care home Friday. Just a local one to get some documents signed or a property sale, and I was quite impressed actually. So I had to ring the bell. The lady came out, all masked up, asked me obviously questions about who I was, where I was from, do I have COVID, have I been in contact with anyone with COVID, and all that sort of questionnaire. Got me to sign some. Wouldn't let me use my own mask.
Interesting.
Right? So they provided me with a fresh mask, provided me with gloves, and also before putting on the gloves, they told me to sanitize my hands. The sanitizer was there as well. So they provided everything there. And after that, I wasn't able to enter the facility. On the side of the front side, they got a bit of a canopy. So my client was sitting under that canopy. So I went and saw my client there. So I was quite impressed with what they were doing.
Yeah.
And
They were
the
obeying the
precaution they were
rules.
taking.